Hello, and welcome to Market Matters, Thompson Hine's podcast series that explores critical legal and regulatory issues affecting the investment management industry. I'm Mike Wible, a partner in the investment management group at Thompson Hine. Today's topic is the SEC's recently proposed amendments to the exemptions from the proxy rules for proxy voting advisors. My guest today is Nathan Holmes, a partner in Thompson Hine's employee benefits and executive compensation practice. Nathan, thanks for joining us today.
Happy to join you, Mike. Thanks.
About 2 weeks ago, the SEC, by a 3-2 vote, approved proposed amendments to the rules applicable to companies that provide proxy voting advice to asset managers and others. Nathan, can you give us an overview of those amendments?
Sure. Thanks, Mike. Happy to. The recently proposed SEC rules deal with proxy advisory firms and the extent to which the proxy statement solicitation rules apply to those firms. And when we talk about proxy advisory firms, two big names here are Institutional Shareholder Services, or ISS, and Glass Lewis. Basically, the SEC's proposed rules define solicitation, or the solicitation of a proxy, to include the main business activities of these two organizations. That is, these are firms that make recommendations to security holders and to asset managers about how they should vote their proxies on various matters, ballots in corporate America, and that's furnished for a fee to their subscribers to their services. And those are both organizations that hold themselves out as experts in providing this sort of service to investment managers. So
that's a change, right, Nathan? Because they previously weren't considered to be soliciting proxies before?
Well, that's a great question, Mike, and it kind of depends who you ask. This whole development is really a battle that has been kind of developing over a long period of time between the SEC and these organizations and corporate issuers as well. The SEC, before it issued the proposed rules, had issued some interpretive guidance basically saying the same thing, that the activities of ISS or Glass Lewis, when they're recommending to their subscribers as to how to vote on proxy proposals, constitute solicitation for purposes of the proxy rules, which would bring into effect the anti-fraud provisions of the proxy rules. The SEC couched that as just a clarification or interpretation of the existing law and said it's not inconsistent with what the law already says. When the SEC came out with that notice, however, ISS fairly promptly responded by suing the SEC for declaratory action to avoid the interpretive guidance on the basis that it wasn't proposed through notice and comment procedures. It was arbitrary and capricious, and it was, from their perspective, it's a huge change. They say, well, we're just investment advisors. We're subject to regulation under the Investment Advisors Act, and that should be the only regime that applies to us. So the SEC came out with interpretive guidance earlier this year. ISS didn't like it one bit. They sued, and now the SEC has come out with these proposed rules. But as I say, this has really been brewing over a much longer time, and from my perspective, it really follows along with the development of the influence of the proxy advisory firms as it relates to voting on executive compensation matters. Now, proxy advisory firms are going to make their recommendations to their subscribers on any matter that's on the corporate ballot. But since 2011, we've had advisory voting, so what's called say-on-pay voting in corporate America, where shareholders get to cast a non-binding advisory vote on whether they approve or disapprove of the compensation of the named executive officers of a public company, as that's disclosed in the proxy statement. And that development in particular, I think, has really served to help heighten the influence of proxy advisory firms like ISS and Glass Lewis. I mean, imagine from your perspective, you may see this. You know, some of the very large investment managers are going to have their own in-house shop that's going to focus on corporate governance issues and how to vote all the items on the ballot. But if you're somewhere in the middle or a much smaller firm, you know, a firm like ISS or Glass Lewis is going to, you know, serve a really useful purpose to you, right? To help you figure out how to vote proposals that may not be, you know, in the core of what your normal stock picking business is.
Well, and some of the largest asset managers will use Glass Lewis or ISS anyway because they have the sheer number of shares that they own in various issuers. It makes it administratively difficult to process all of those proxy ballots and determine how to vote in each case.
Absolutely right. And It's interesting. One of the things that was pointed out in ISS's lawsuit, and it's addressed to some extent in the SEC proposed rules preamble, is that in some cases ISS or Glass Lewis will be just applying the custom voting policies of their client, right? But the SEC's view is even that action is the solicitation of a proxy and implicates the anti-fraud rules, and also some new provisions which would apply if these proposed rules go into effect.
So even though under the proposed rules, proxy advisory services would be considered to be soliciting, they are able to get out of the sort of solicitation section of the rules by complying with certain provisions. Is that right?
That's right. They'd be subject to the anti-fraud rule in any case, right? They couldn't make material misstatements or omit facts that would be materially misleading. But in order to avoid having to file proxy materials themselves with the SEC, the proposed rules would put in place something that's a brand new process that doesn't exist today and would be very interesting. For one thing, it would require certain disclosures by the proxy advisory firms about conflicts of interest. And this is one of the topics that corporate America has been, from my perspective, quite fairly complaining about for years, because particularly in the case of ISS, they have proven very adept at sort of monetizing their position in between institutional investors and corporate issuers. So
what do you mean by that?
Well, so ISS's principal client, right, is going to be the investment advisors or other institutional investors who are hiring them to give recommendations about how they should vote all of these ballot items that are showing up throughout their portfolio. So those folks pay ISS money for that service. On the other side of the coin, that's money coming into the right hand of ISS, you might say. And the money coming into the left hand of ISS comes from those corporate issuers who are trying to get their proposals approved, whether that be the approval of a new equity compensation plan, something I spend a large portion of my time dealing with, or the approval of that non-binding say-on-pay vote, which I also spend a fair amount of time working with. So if you're an issuer and you're going to go to shareholders and ask for approval of a new stock plan, for example, you're going to think pretty seriously about dealing with ISS first. And ISS has technically, it's a subsidiary of ISS. It's ISS Corporate Solutions, I think is the name they're using for it now. That's the entity that a corporate issuer can hire to evaluate their stock plan proposal and or to give comments on the compensation discussion and analysis, CD&A section of the proxy for how they might dress that up to appeal to shareholders for a say-on-pay vote. So ISS is also receiving funds in many cases from corporate issuers who are paying to have a warm and fuzzy feeling that whatever they're going to ask shareholders to approve will get the ISS seal of approval before they file it.
Okay, so they're asking ISS to tell them how to structure the proposal so that it passes ISS muster, so that ISS can then recommend it to investors to approve.
Exactly right.
Okay.
Exactly right.
So what else besides that? That's obviously a clear conflict. What other provisions are there?
That's right. So that conflict would need to be more prominently disclosed than it is now. But more interestingly, beyond that, these new rules would set in place, if they are finalized, a process whereby corporate issuers who file their proxy materials on a timely basis could be given, as of right, an opportunity to review ISS's and comment on ISS or Glass Lewis's or any other proxy advisory firm to review and comment on their proxy report, voting recommendations before they're finalized. And also, the corporate issuers would be given the right, the proxy advisory firms, to include in their materials a hyperlink or other means of attaching a statement by the corporate issuer responding directly to the proxy advisory firm's report. That doesn't exist today. Of course, you can respond publicly, and issuers would need to do that as well. They're going to have to file additional proxy soliciting materials. But you could kind of ride along, if this process goes through, you could ride along in ISS's report. And those notice and comment periods kind of vary depending on how soon the issuer files its report. As long as you file your proxy statement, that is, at least 25 days before the meeting, you would get at least some advance notice of what ISS was going to say and the opportunity to include your comments in ISS's materials. If you file your proxy statement at least 45 days before the meeting, you get a little more advance notice. But that would be a really interesting process to see how that plays out.
Well, interesting to say the least, because then the ISS customer or the investor is going to be could possibly receive two recommendations, right? Mm-hmm. The ISS's recommendation as well as the proxy the issuer, their view of ISS's recommendations. That sort of puts the investor, particularly a pension plan or a corporate, something like that, in a really difficult situation.
Well, I think that's right. This is a new innovation that the SEC is trying out. I think it could be very useful to issuers, just making sure that your point gets across at the same time that someone's reading the ISS report. That same information is right there. They don't have to go and look at additional proxy materials or soliciting materials that you might file with the SEC. But the schools of thought kind of differ on how to respond to ISS when they provide a negative recommendation on an issuer's proposal. And I think the initial trend when ISS, when say-on-pay votes began and ISS started occasionally making negative recommendations, was to respond very aggressively to what ISS had to say and critiquing their methodology and things like that. I think most people found, however, that that's not generally a very productive means of dealing with your shareholder base, and that it's more important just to be out there proactively before it gets to ISS, and then, if necessary, afterwards through shareholder engagement, really telling the story of what your compensation program is, why it's structured the way that it is, and getting feedback from your shareholders about what it is that they like, don't like, would like to see improved about how you pay your top executives.
One of the things you said earlier on was the anti-fraud provisions of the proxy rules. It's my understanding that this proposal also sort of broadens, I guess, the anti-fraud rules or the applicability to the proxy solicitors' advice.
Well, I think that's right. Well, what it does is really it would make those rules clearly applicable to the advice of proxy advisory firms. I think their view right now is if we're just regulated under the Investment Advisors Act, the rules that apply there in general under the proxy statement rules don't apply to research reports that are published by proxy advisory firms. But here they clearly would be if the SEC proposal is adopted.
Yeah. Well, there was an article yesterday not an article, but an editorial from Carl Icahn in the Wall Street Journal yesterday.
I saw it.
Right, and I think one of the points he makes is that by saying that any misstatement or omission from the proxy advisory service could constitute fraud is a way of shutting down the proxy service advisory business and sort of muzzling them. He's obviously looking at it from an activist shareholder standpoint.
That's right. Well, clearly, there's no doubt in my mind that this is a shot across the bow from the SEC towards proxy advisory firms. And we should say, going back earlier this summer when the SEC issued the initial interpretive guidance, there was another piece of guidance that was issued really to investment advisors themselves, which among other things suggested that, there's some level of diligence that an investment advisor needs to do before it just decides to rely on the advice of a proxy advisory firm like ISS or Glass Lewis. Yeah. But I do think this is, and again, in many ways, this is a conflict that's been developing for a number of years, and corporate issuers have had a lot of concerns with the way ISS, runs its business. Not just the obvious conflict of issues that we talked about, but also, there are substantive positions that ISS takes. The ones that I see relate to executive compensation in some areas that many corporate issuers don't agree with. Things like saying that, stock options are not performance-based compensation. That's an ISS position. It's not the only way of looking at the world. Sometimes a sense that ISS, while it generally does a very good job of sort of articulating what its methodologies are for reviewing compensation-related shareholder proposals, there's still a sense that it's not always clear how things get applied, how those rules are applied in practice, and whether they're always applied consistently. And sometimes there's a sense that, ISS may be misreading the facts and may have something wrong about a company's compensation program. So this has been something that corporate issuers have been raising to the SEC for a while, and then the SEC is taking action.
Yeah, and I think that point you just made was reflected in the guidance that you mentioned earlier from the SEC to asset managers, which says, basically look at whether there's any conflicts of interest that might be, present in the advice that Glass Lewis or ISS has given. Also, even though you get the advice from the Proxy Advisory Service, you should be looking on a fund by fund, client by client basis to determine whether that advice is appropriate for your client or for the fund that you're advising. So it's very interesting. So Nathan, what do you think the prognosis for passage or final adoption of the rule is?
Well, that's a little tough to say at this point, Mike. As you pointed out, it's a 3-2 vote, and it was a 3-2 vote on the issuance of the earlier interpretive guidance as well. So that's not a very strong margin. I think we're going to see, I would expect, a lot of comments. The comment period is open. It was a 60-day comment period. I think the proposed rules came out November 5th, if I remember correctly. So I think there's going to be a lot of comments submitted. I doubt we'll see anything one way or the other in time for the main proxy season next year in 2020. But there's a good chance that something could happen here. There are always political events that could intervene, and who knows where this ultimately goes. But it's going to be, one way or the other, very interesting to watch. From my perspective as someone who advises public company issuers, it's a little hard to suppress the Schadenfreude here of enjoying ISS, who's been in some ways a thorn in the side, or at least an annoyance to corporate issuers for a while, to see them needing to address the SEC's concerns, and these are real legitimate concerns. But I also begin to wonder whether, if these rules do go through, will this be all that we would hope it to be? Sometimes you have to be careful what you wish for, and if this is something that, if the ultimate result of this is a situation where proxy advisory firms have less influence or authority in the process, is that necessarily a good thing? It seems like it might be, but to the extent that it creates less predictability about the results of balloting for proposals that relate to executive compensation, for example, I'm not sure that that's necessarily a good thing. It may also advantage, or give more power to certain segments of the corporate shareholder base if ISS's or Glass Lewis's recommendations are taken less seriously in the future. Yeah. But either way, it'll be a very interesting development.
I agree with you that there's going to be a lot of comment letters, a lot of particularly since at the same day the proposal on shareholder proposals came out. And I think with the rise of ESG funds and impact investing, there's going to be a lot more voices in the discussion than there previously might have been on a topic like this.
Yeah, I think that's absolutely right.
So, well, Nathan, thanks so much for joining us today. It's very informative talking with you as always. I appreciate your time.
It's been a pleasure, Mike. Thanks a lot.
You're welcome. If you'd like to learn more about today's topic or Thompson Hine's investment management practice or Thompson Hine's employee benefits and executive compensation practice, please visit thompsonhine.com. With approximately 400 lawyers in 8 offices, Thompson Hine is a full-service business law firm recognized for innovation and client service. Our Smart Path approach provides clients with service that is predictable, efficient, and aligned with their goals.